Then many constructions have been laid down and extended throughout in India, and efforts were made just to for its extension. And at that time, when this act was passed, Indian Railways Act 1890, uh, then the railways was managed by merely by private companies, and merely by the private companies, and uh, the government of India was doing the job as a coordinating agency, right? So, as I said earlier, the extension of railways has been done, and there was a need to frame a consolidated act which must have the which must provide the government of India all authority, right? So therefore, there was a need to just form, just enact consolidated legislation to run and regulate the railways. And this Railways Act 1989 was passed in the year 1989. And several amendments have been done in the recent past under this act. And in the year 1994, some amendment has been done in the year 1994. The aspects relating to the compensation for just deprived person, injured person during untoward incident, and after section 124, section 124 capital A was added, and in the year 2003, the major amendment taken place. And we will discuss these amendments later on. And then again in the year 2005, the aspects related to Rail Land Development Authority have been added, and in the year 2008, the aspects relating to the land acquisition for special railway projects have been added. Here is the classification of chapters. Preliminary have been given under this act under chapter 1. So please note down, this act, this law consists of 200 sections covered under 16 chapters. You can see the 16 chapters, and there are 200 sections in this Railways Act 1989. I repeat, 200 sections are there. So preliminary and definitions have been given under chapter 1, and railway administration has been provided under chapter 2. Chapter 2A deals with the Rail Land Development Authority, RLDA, and under this chapter 2A, sections 4A to 4I have been added, and total 9 sections 4A to I has been added, and chapter 3 deals with the Commissioner of Safety, Railway Safety. Chapter 4 provides the construction and maintenance of works. Chapter 4A provides the land acquisition for a special railway project, and chapter 5 deals with opening of railways. Chapter 6 provides the fixation of rates. Chapter 7, railway rates tribunal. Chapter 8, carriage of passengers, and carriage of goods has been provided under chapter 9, and chapter 10 deals with the Chapter 10 deals with the special provisions as to goods booked. And then responsibility of railway administration as carriers has been given under chapter 11. Chapter 12 deals with accidents, and chapter 13 liability of railway administration for death and injury to the passenger due to accident. Under this chapter, the chapter 120, section 124 capital A has been added, compensation for passenger during injured during untoward incident. Then chapter 14 provides the regulation of powers, regulation of hours of work and period of schools. And chapter 5 deals with the penalties and offences. Mm, Chapter 5 deals with the penalties and offences, and chapter 6 deals with the miscellaneous, right? So we will mainly focus on this penalties and offences, chapter 15. Now we come to see the agencies responsible for railway security. So as I asked earlier, uh, and then gone through the basics of law and security in my last preceding uh, class, online class. So I would like to ask, uh, what is the constitutional difference between RPF and police? RPF and police, क्या अंतर है? कॉन्स्टिट्यूशनल अंतर जल्दी से बताएं, फिर हम आगे बढ़े. What is the difference between police and RPF? कोई आइडिया
Sir,
है?
RPF is force of union and police is force of state.
वेरी गुड, वेरी गुड. तो ये हमने उस दिन भी कहा था कि both are the forces, but RPF is the force of union and police is the force of state. This is oftenly asked in your exams. So RPF has been constituted under RPF Act 1957 and police has been constituted under the Police Act 1861, and this GRP is the part of police, and 50% emoluments and payments are paid by the railway ministry to states for GRP, right? Now, this was the arrangement, and the duty of the RPF was given under RPF Act 1957. प्रायर जो 2003 का अमेंडमेंट आया है, 2003 का अमेंडमेंट, आई रिपीट, so prior to the amendment, the duty of the RPF was to protect and safeguard the railway property, to do any other act conducive to the better protection and security of a railway property. And after the amendment, what has been done here? The duties of the RPF, member of the RPF, has been enhanced, and to protect and safeguard the railway property, passenger and passenger area, and to do any other act conducive to the better protection and security of a railway property, passenger and passenger area. So, ladies and gentlemen, you can see how this railway property, the expression has been substituted by these three: railway property, passenger and passenger area. So what is passenger and who is passenger? Passenger कौन है? बताइए साहब. पैसेंजर की डेफिनेशन जानते हैं आप लोग? बातचीत नहीं करेंगे तो मजा नहीं आएगा पढ़ने में. Who is passenger? आशीष कुमार मीना,
Yes, sir.
पैसेंजर कौन है? हु इज पैसेंजर?
Sir, those who are go one place.
हेलो,
Hello.
हाँ बोलिए।
Sir, those who are going from one place to another place by train. All train.
कार्तिकेय सिंह,
Yes, sir.
पैसेंजर कौन है?
Sir, passenger is a person who is traveling between two stations by train.
ओके, बहुत बहुत बढ़िया बात बताई। लेकिन लेकिन किसी अथॉरिटी से जाता होगा ना, ट्रेन में
Yes, sir.
चढ़ने के लिए कोई अथॉरिटी लेनी
Ticket.
पड़ती होगी।
Sir,
Sir,
one who
ticket
has
लेके
valid
जाता है।
ticket.
Passenger is a person under section 229 of this act. Passenger has been defined. Passenger is a person traveling with valid pass or ticket. So one line definition of passenger has been given under section 229 of this act. Passenger is a person traveling with valid pass or ticket, right? Then what is passenger area? Passenger area has been defined under section 2CB of the RPF Act, and passenger area means and include any platform, train, yard, and other areas which are frequently visited by the passenger, Therefore, this passenger area in field, when you will join your working post, then you will find there is a mentioning of passenger area as the circulating area, right? But passenger area include any platform, train, yard, and such other areas which are frequently visited by the passengers. So ये भी अक्सर एग्जाम में पूछा जाता है। डेफिनेशन, पैसेंजर एरिया, पैसेंजर, रेलवे प्रॉपर्टी पूछी जाती है। रेलवे प्रॉपर्टी अभी हम आरपीओपी एक्ट जब बात करेंगे तो उस पर बात करेंगे, ठीक है। नाउ penalties and offences have been given under sections 137 to 182 under chapter 15 of this act, and the amendment, as we are going to discuss, penalties and offences, actually we will mainly discuss with the penalties and offences, and from this portion Railway Act, you will find even in your question paper, law question paper, 10 marks maybe from this portion, Railways Act. From the RPUP Act, even 5 to 7 marks, right? So this session is most important session as you can consider. So please pay attention and be attentive in these sessions. So we will mainly focus on this, and after the amendment, in 2003, the RPF was given power to deal with the 39 offences out of 42 offences under these sections 137 to 182, and previously those sections, those offences were dealt by the GRP and local police. Now after the amendment, these offences are being dealt by the RPF, officer authorized, So please go through these sections, and maximum you will find out of 42 sections, the 3 sections, serious sections relating to the sabotage and punishable with some serious offenses. Those offenses have been put into the categories of the for the RPF can arrest without warrant, right? तो हम बताते रहेंगे कि कहाँ कहाँ इसको बिना वारंट गिरफ्तार करने का अधिकार है ऑफिसर अथराइज्ड को, कहाँ पुलिस को अधिकार है गिरफ्तार करने का, और कहाँ पर बिना वारंट गिरफ्तारी का अधिकार नहीं है। तो केवल हेडिंग और पनिशमेंट दिया हुआ है। We will share these presentations even in the evening, and please go through. आप सभी से मैंने ये भी रिक्वेस्ट किया था कि रेलवे बेसिक्स ऑफ लॉ एंड रेलवे सिक्योरिटी को पढ़ लीजिएगा। आपने मैंने प्रेजेंटेशन भी शेयर किया था, पढ़े हैं क्या? पढ़ाई किए कि नहीं सैटरडे संडे में? हेलो, चिराग, मिस्टर चिराग झा।
यस सर।
केवल RT-PCR के टाइम मोबाइल खोल के पढ़ नहीं रहे थे आप लोग? पढ़े हैं कुछ?
नहीं पढ़ा।
बेसिक्स ऑफ लॉ नहीं पढ़ा?
सर अब पढ़ेंगे सर, आज से मंडे से।
हाँ, पढ़ लीजिए, पढ़ लीजिए। एग्जाम है। एग्जाम कब है लॉ का?
फ्राइडे को है।
हाँ, तो पढ़ना पड़ेगा ना।
यस सर।
सभी को शेयर कर दिया था वो वाला?
सर पीपीटी शेयर्ड है।
अच्छा, सुचिता ने भी कर दिया था?
यस सर।
हाँ हाँ, तो थोड़ा सा सीरियस रहिए, नहीं तो सब एकदम से कंफ्यूज हो जाएंगे इकट्ठे पढ़ेंगे तो। और यहाँ क्लासेस में थोड़ा सिंसियर रहिए तो सब दिमाग में रहेगा। So penalties and offences we are just going to discuss. Section 137, fraudulently traveling or attempting to travel without proper pass or ticket. This offence is punishable with maximum up to 6 months imprisonment for imprisonment or fine up to rupees 1,000 or both, in addition to the payment of ordinary single fare plus excess charge. Then section 138, levy of excess charge and fare for traveling without proper pass or ticket or beyond authorized distance by passenger, liable to pay ordinary single fare plus excess charge. If accused fails to pay said sum, may be liable for imprisonment for maximum imprisonment of 1 month. So under these two sections, officer authorized is authorized to arrest without warrant. और जहां जहां हम कोई चीज इंगित नहीं करते, वहां वहां आप समझिएगा कि ये बिना वारंट गिरफ्तार करने का अधिकार है। एंड ट्राई टू लिसन। Several circumstances are asked. Somebody is traveling without proper pass or ticket, where it has been punishable, and what is the punishment, ये पूछा जाता है। अक्सर 4-5 सेक्शंस को ऑफेंसेस पे टिप्पणी पूछी जा सकती है। एंड आई वुड लाइक टू रिक्वेस्ट एवरीबडी, so where I will suggest, please note down those sections which are laid down under section 179 subsection 2. Out of 29 sections, only 4 4 sections are having the provision of punishment up to 5 years, 3 to 5 years of offenses. Please note down, right? So, penalty for transfer of ticket, penalty for transfer of ticket and touting. Section 142, penalty for transfer of ticket, imprisonment up to 3 months or with fine up to rupees 500 or both. तो यहाँ भी बिना वारंट गिरफ्तार करने का अधिकार है आरपीएफ ऑफिसर अथराइज्ड को। सेक्शन 143, unauthorized carrying on of business of procuring and supplying of railway tickets, imprisonment up to 3 years or fine up to rupees 10,000 or with both. So please note down, section 143 is the important section for officer authorized, where the officer authorized has even in all sections power to arrest without warrant, but here punishment is 3 years. Then we will just discuss these sections where the punishment is 3 years to 5 years, 3 to 5 years, and why these offences are taken as warrant cases and billable, non-billable offences. So in the last we will discuss this one. So please note down 143. This is 143 where the punishment is 3 years. This is important. Then penalty for hawking, begging, nuisance, etc. Trespass, section 144, prohibition on hawking, begging, etc. Imprisonment up to 1 year or fine up to rupees 200, fine up to rupees 2,000 or with both. This is the punishment. Section 145, drunkenness or nuisance, imprisonment up to 6 months and fine up to rupees 500. And for trespass, imprisonment up to 6 months or fine up to rupees 1,000 or with both. अगर कोई रेलवे की परिसीमा में बिना अधिकारिता के विदाउट टिकट घुसता है, तब की ये स्थिति है। And under these all 3 sections, officer authorized is authorized to arrest without warrant. Penalty for unnecessary interfering with the means of communication, etc. Needlessly interfering with the means of communication under section 141, alarm chain pulling ACP, उस मामले में 1 साल तक का कारावास और मैक्सिमम 1,000 रुपए तक का जुर्माना, ये ऐसा बताया गया। सेक्शन 146 provides the obstructing of railway servants in his duties, imprisonment up to 6 months or fine up to rupees 1,000 or with both. ये section 174, obstructing running of trains, may be railway servant, there may be railway servant or maybe outsider. तो ये सेक्शन जानी जाती है रेल रोको, धरना प्रदर्शन, स्टेर, जैसे अभी गुजर आंदोलन वहां चल रहा है, कई बार जाट आंदोलन, तो ये आंदोलन आरक्षण का आंदोलन, तो आप देखिए यहाँ पर railway is the soft target, and sometimes the railway is become the just victim of the aggression sometimes of the धरना प्रदर्शनकारी, एजिटेशन वाले और जितने लोग के ये सब रहते हैं ग्रुप वाइज। तो it is the, although it is the utmost duty of the state of the state to maintain public order, public tranquility, public peace, this is the subject of the state, right? So if you see the entry 1 of the second list, list 2 of the 7th schedule of the Indian Constitution, then you will find that list 2 entry 1 provides that it is the responsibility of the state to maintain public order. Public order वहां पे लॉ एंड ऑर्डर नहीं लिखा है, बल्कि पब्लिक ऑर्डर लिखा है. पब्लिक ऑर्डर को डील करने की जिम्मेदारी किसकी है? स्टेट की है, स्टेट पुलिस की है, स्टेट फोर्स की है, दैट इज पुलिस. ठीक है. So affecting running of trains, railway servant of or outsider, imprisonment up to 2 years or fine up to rupees 2000. तो ये दिया हुआ है. ये जो सेक्शंस हैं, 3 सेक्शन से, रेलवे रेट्स ट्रिब्यूनल से, रेलवे क्लेम्स ट्रिब्यूनल से, या कहीं न कहीं इन्होंने तो यहाँ पर बिना वारंट गिरफ्तार करने का अधिकार नहीं है ऑफिसर अथॉराइज्ड को, बट अगर कोई रिक्विजिशन कहीं से आता है रेलवे के पास, तब गिरफ्तार करने जैसी स्थिति होती है. These are serious offences, as I said earlier. Section 150, maliciously wrecking or attempting to wreck a train, imprisonment for life or with rigorous imprisonment for 10 years or sentenced to death. You might have heard the name of this जहां पर की
कौन सर?
हेलो, हेलो, local law. This section is very serious. आपने देखा होगा जब गाड़ी में आग लगा दी जाती है, गिरा दी जाती है, ट्रैक को काट दिया जाता है, ये वैसे ही धारा है जैसे कि धारा 302 मर्डर के लिए है. देख रहे हैं, डेथ सेंटेंस तक भी है, फांसी की सजा भी है उसमें, सेक्शन 150 में. सो दिस इज सीरियस एंड इज डेल्ट बाय द लोकल पुलिस और जीआरपी. Section 151, damage to or destruction of certain real properties, imprisonment up to 5 years or fine or up to this one. Section 152, maliciously hurting or attempting to hurt persons traveling by railway, imprisonment for life or for a term up to 10 years. So these serious sections are even still are dealt by the GRP and local police. So penalty for endangering safety of passengers, self. So endangering safety of persons traveling by railway by willful act or omission, imprisonment up to 5 years, or section 154 encouraging safety of persons traveling by railway by rash or negligent act or omission, imprisonment up to 1 year or fine up to fine or both. And traveling on roof, step or engine of a passenger train. This is also under these all sections, the RPF officer or officer authorized to arrest without warrant. Sections 172 to 176. Those are framed for a railway servant only, and railway servants may be taken up, right? So, section 175, endangering safety of passengers by railway servant. So, imprisonment of 2 years or fine or both. So, these railway servants may also be arrested without warrant by the railway servant or by the officer authorized, sorry, by the officer authorized. Penalty for causing inconvenience to passenger, section 155, entering into compartment reserved or registering entry into a compartment not reserved, fine up to rupees 500. सेक्शन 162, ये सब अक्सर पूछी जाती है सेक्शंस. सेक्शन 162, entering carriage or other place reserved for female, fine up to rupees 500. Section 166, defacing public notices, imprisonment to up to 1 month or fine up to rupees 500, or with both. Section 167, smoking is punishable up to 100 rupees fine under the Bear Act, but this is 200 rupees is by virtue of Cigarette and Tobacco Act, 200 rupees. So under section 160, opening or breaking of level crossing gate, imprisonment up to 3 months for opening and 5 months for the breaking of level crossing gate. Section 161, negligently crossing unmanned crossing gate, unmanned level crossing. So imprisonment up to 1 year. You will find after joining the working post, most of the unmanned level crossing have been demolished, like खत्म कर दी गई हैं and stopped, removed. Hello. नमस्कार. आप एक बार फिर से उस पे हेलो करिए अपने व्हाट्सएप पे. Then section 176 obstructing level crossing. अगर कोई रेलवे सर्वेंट देर तक बंद रखता है अननेसेसरी रेलवे क्रॉसिंग को, तो उस रेलवे सर्वेंट को भी पनिश करने का एक तरह से इसमें प्रावधान है रेलवे एक्ट में. एंड अभी तक Section 164 unlawfully bringing dangerous goods on railways, imprisonment up to 3 years or fine up to rupees 1,000 or with both, and also will be liable for any loss, injury or damage which may be caused by reason of bringing such goods on railways. एंड अंडर सेक्शन, तो यहाँ भी 3 साल का पनिशमेंट है आपको. अभी जिसमें आरपीएफ या ऑथराइज्ड को जो सेक्शंस 179 सबसेक्शन 2 में जो हैं उनको हम देखेंगे. 4 सेक्शंस हैं जहां पर कि सब 3 से 5 साल तक का कारावास है. 143, 153, 160 and 164. Please note down these sections. 143, 153, 160 and 164. Now offenses by railway servant. एक सेक्शन आपने देखी थी 145, जहां पर कि जनरल पब्लिक को भी या रेलवे सर्वेंट जो ड्यूटी फ्यूटी में नहीं है वो भी 145 में अगर कोई दारू पी के शराब पी के यात्रा कर रहा है या है तो उसको बिना वारंट गिरफ्तार करने का अधिकार है ऑफिसर अथॉराइज्ड को. Section 173 abandoning train without authority, imprisonment up to 2 years or fine up to rupees 1,000 or with both. Section 177 false return railway servant, imprisonment up to 1 year or fine up to rupees 500. Miscellaneous sections are there. Some miscellaneous sections of offences are there. Altering or defacing pass or ticket, imprisonment up to 3 months or fine up to rupees 500 or both. Section 159, disobedience of drivers or conductors of vehicles to directions of the railway servants, imprisonment up to 1 month or fine up to rupees 500 or both. Section 168, offences committed by children under 12 years of age, guardian to give a bond for such amount and for such period as the court may direct for good conduct of the child. So, चिराग जी आप पढ़िए जरा इस स्लाइड को तो प्लीज रीड. Please read.
Power of arrest. Section 1791. Arrest for offences under sections 150, 151 and 152. Offender may be arrested without warrant by any railway servant or police officer not below the rank of a head constable. Section 179 subsection 2. If any person commits any offence mentioned in sections 137 to 139, 141 to 147, 153 to 157, 159 to 167, and 172 to 176, he may be arrested without warrant or other written authority by an officer authorized.
So all of you are, thank you Mr. Chirag, all of you are requested to calculate how many sections under section 179 subsection 2 is there. How many sections are there under section 179 subsection 2? Please calculate or competent. So please calculate fast. कितनी sections हैं इसमें? कितनी सेक्शन है कैलकुलेट नहीं कर पाए आप लोग
29 सर।
सारे इंजीनियर्स मिलके?
29 सर।
हाँ, तो इतनी देर क्यों लग रही है बताने में? Thank you, Mr. Arjun. 29 sections are there. 29 offences are there under section 179 subsection 2. Here 3 offences are there. So total, if you calculate, it becomes 32 offences and 10 sections are here under section 180 subsection 1. Mr. Arjun, please read this slide, please. Yes. Can you read, please? Arjun left. Aninder Singh. Aninder. बहुत खतरनाक रोल नंबर है. Mr. Aninder Singh, are you there? अरे मयंक, मिस्टर मयंक.
यस सर.
आप ये स्लाइड पढ़िए जरा.
सेक्शन 180, arrest of persons likely to abscond, etc. Any person committing offence under this act other than offences mentioned in section 179(2). Person refusing to give access charge and also refusing to give his name and address, or gives incorrect address, or person likely to abscond.
Thank you, Mr. Mयंक. There are 29 sections under section 179 subsection 2. Under section 179 subsection 1, there are 3 sections for police, authorizing the police officer or police, authorizing the RPF or officer authorized for 29 sections, and 10 sections are here under section 180 subsection 1. So total offences under the Railways Act, 42 offences are there. Out of 42 offences, please note down, 3 offences are pertaining to the GRP and police, and out of all sections mentioned under section 179 subsection 2, out of 29 sections, only 4 offences are having the punishment 3 to 5 years. Under section 143, the punishment is 3 years maximum. Under section 153, 5 years. Endangering safety of traveling passenger, 5 years. Under section 160, for opening the level crossing gate, opening 3 years, for breaking 5 years, and bringing dangerous goods on railways under section 164. So under section 164, the maximum punishment is 3 years. So ladies and gentlemen, please note down those offences where the punishment is 3 to 5 years, those offences are taken as non-bailable since punishment is 3 years or upwards, and taken as warrant cases where the punishment is exceeding 2 years, right? So here the officer authorized have got power for dealing these offences, and seven sections in 2003 amendment, seven sections, procedural sections were added, and RPF and officer authorized or RPF has been given power like police for these 29 offences and plus 10 offences. The RPF has to do the job as under the criminal procedure code police performs, right? So police like power has been, CRPC power has been given to the RPF also under section 180 capital E. तो इनको बहुत ज़्यादा जाने की जरूरत नहीं है। इसको फिर ये ऑफिसर अथराइज्ड का जो एक तरह से नॉमेनक्लेचर मिलता है, इसमें मुझे लगता है कि पार्टिसिपेंट जुड़ के अपना जो है साइलेंट हो जाते हैं, पता है, बंद करके जोड़ के बंद करके सो भी जाते हैं।
नहीं सर, नहीं सोता है।
नहीं, ये वेयर इज हनिंदर सिंह? आई एम आस्किंग वेयर इज हनिंदर सिंह?
यस सर।
तो आपसे मैं अभी पूछ रहा था संधू साहब, तो आप जवाब क्यों नहीं दे रहे थे? आपको तो मैंने मार्क कर दिया, एब्सेंट मार्क कर दिया है। वेयर आर यू नाउ?
सर रूम पे।
हेलो
सर रूम पे।
देखिए, जो रिस्पॉन्ड नहीं करेंगे फिर मैं वीडियो भी बोलूंगा ऑन करने के लिए। अगर नहीं दिखाई देंगे, नहीं बोलेंगे, तो मैं आई विल मार्क एब्सेंट and I will just guide your CR to mark yourself absent, right? So please, everybody should be attentive here. Just please, Aninder, please read this slide. आप इस स्लाइड को पढ़िए जरा जो जल्दी से।
Officer authorized according to GOI notification date 17 May 2004, the central government has notified all the officers of and above the rank of assistant sub-inspector in the Railway Protection Force as the officer authorized for the purpose of this act. Second, according to GOI notification dated 2nd August 2004, officer noted below the rank of a Group C officers of the Commercial, Operating or Vigilance Department in the Ministry of Railways as the officer authorized for the purpose of Section 179.
क्या डिफरेंस है इन दोनों में? दोनों गैजेट नोटिफिकेशन में कोई डिफरेंस पता चल पा रहा है? प्लीज सी द लास्ट लाइंस, कंपेयर लास्ट लाइंस. All participants are requested to see. अगर ये पूछ लेंगे एग्जाम में तो आप जवाब नहीं दे पाओगे।
जो पहले वाला है वो पूरे एक्ट के लिए है और वो सेक्शन 179 के लिए है बस।
और सेक्शन 179 में क्या दिया हुआ है देसवाल साहब?
तो 179 का सेक्शन 2 था।
ये मैं आपको दिखा देता हूँ सेक्शन, ये क्या दिया हुआ है सेक्शन 179 में? क्या दिया हुआ है?
पावर ऑफ अरेस्ट और जो वो 29 अलग से
हाँ,
नोट कराए थे आपने।
पावर ऑफ अरेस्ट दिया हुआ है, तो इनको भी गिरफ्तारी करने का अधिकार है। ये जो the officers not below the group C officers are also having power to arrest without warrant, but whenever these Group C and above officers are arresting any culprit, then that arrested person shall be handed over to the RPF for further action, right? So, for RPF, officer authorized are taken as ASI and above. So this should be very clear. Otherwise, if anything related to this is asked in exams, you will not be able to comfortable to answer, right? So please keep in mind. Protection of sanction of action in good faith. So no shoot, prosecution, or other legal proceedings shall lie against the central government, any railway administration, or a railway servant, or any other person for anything which is in good faith done or intended to be done in pursuance of this act or any rules or orders made under there. Now, magistracy and jail and judiciary is the subject of the state. Judicial magistrate comes from the state, and jail is also managed by the jail is the state subject. So these magistrates, railway magistrates, are the ACJM rank judicial magistrate, additional chief judicial magistrate, and they are having power to pass sentences up to 7 years maximum, and fine depends on their discretion. So thank you very much. Now I would like to go through this one. तो एक तो ये ध्यान कर लीजिए, रेलवे एक्ट में बहुत सारी डेफिनेशन जो आती हैं सो आती हैं पैसेंजर एरिया, पैसेंजर, रेलवे प्रॉपर्टी डेफिनेशन अभी यहाँ हम बताएंगे आपको, वो भी पूछी जाती है, वो डिस्क्रिप्टिव में आते हैं, और कम से कम 4-5 सेक्शंस को आप याद कर लीजिए. हो सकता है कि आउट ऑफ ऑल सेक्शंस 5 or 6 sections may be asked to write the short note on those offences, and some objective type of questions are also asked. Traveling on a roof, traveling without ticket, traveling in ladies compartment, तो इस तरह का कोई सेक्शन पूछा जा सकता है. So please be careful and be attentive and prepare for that. Now we come to discuss the Railway Property and Lawful Possession Act 1966.
सर
जी
सर, जो आपने बताया था स्पेशल रेलवे मजिस्ट्रेट्स कैन गिव मैक्सिमम 7 years की सेंटेंस,
हाँ,
लेकिन सर जो सेक्शन 150 था जिसमें डेथ सेंटेंस भी दे सकते हैं, तो वहां पे कौन देगा?
150
जिसमें डेथ
वो सेंटेंस टू डेथ 150 में है. 150, 151, 152, these are the sections offences pertaining to the GRP and local police. These magistrate, the railway magistrate, will take cognizance and just forward the case to the sessions court of the district.
Okay,
right?
Yes, sir.
And these offences are tried, serious offences pertaining to the police, 150, 151, 152, are tried at the district courts, like sessions court, right?
Okay, sir. Thank you.
Okay, thank you very much. Now, these are oftenly asked in your exams. So please be attentive towards this salient feature of the RPUP Act 1966. This is most important. Please prepare for that. So the officers of the RPF are vested with powers of arrest, investigation, inquiry, and prosecution of offenders of the railway properties under Railway Property Unlawful Possession Act 1966. The definition of the railway property has been extended to include the booked consignment. The Act, it extends to whole of India. Now, even prior to the abrogation of the Article 370 in Jammu and Kashmir, this was written in this Act in the year 1966 that it extends to whole of the India. Otherwise, you will find in several of acts, in several laws, there is a mentioning that it extends to whole of India except the Jammu and Kashmir, right? But after the abrogation, several thousands of the laws are applicable to the Jammu and Kashmir. नहीं तो वो आर्टिकल 370 की वजह से कोई भी एक्ट लागू नहीं रहता था, कुछ में जो स्पेशली मेंशन्ड हुआ करते थे, जैसे ये आपका आरपीओपी एक्ट है, तो इट एक्सटेंड्स टू होल ऑफ इंडिया. The offences under this act are non-cognizable in order to ask the jurisdiction of the state police. And offences under this act are non-bailable. So please इसको कंठाग्र कर लीजिए, रट लीजिए, रट्टा मार लीजिए, अक्सर पूछा जाता है. Now we come to discuss the definition of the railway property. So railway property has been defined as railway property includes any goods, money, valuable security or animal belonging to or in the charge or in the possession of a railway administration. So please remember and keep in mind the definition of the railway property. It is also oftenly asked. Now we come to see some penal sections, and I would like to refer the introduction even. Only one amendment has been done in this act since long, and in 2012 the RPUP Act has been modified, amended, and two penal sections are there, section 3 and 4. Section 3 and 4, there are two penal sections, these have been amended, and the procedure for inquiry under section 8 has also been amended, section 8. So three sections, please note down, these are also important and are oftenly asked in your exams. So section 3, 4 and 8 have been amended. कोई बता सकता है कौन कौन सी सेक्शन अमेंड हुई हैं? Mr. Bipul Malviya.
3, 4 and 8, sir.
3, 4 and 8, and these are oftenly asked in your exams. So हम देखिए जैसे जैसे हम पढ़ा रहे हैं वैसे वैसे आपको बता रहे हैं कि ये इम्पोर्टेंट है, बट ये पर्चा आउट नहीं है, लेकिन ध्यान कर लीजिए कि इन पर ज्यादा फोकस करना है, ऐसे ये सब ज्यादा पूछे जाते रहे. ठीक है. Now section 3 defines the offence under this act, and we will see the amended how these sections have been amended. Section 3 and section 4 we will read taking the amendment into consideration. And offences are not cognizable with power of arrest, section 5, 6. अच्छा, एक चीज और जान लीजिए, this RPUP Act consists of total sections. 16 sections are there. How many sections are there?
16, sir.
16. How many sections are there under Railways Act?
200.
200. Very good. How many chapters are there in the Railways Act 1989?
16.
Very good. तो ये सब ध्यान रखने की चीज है. थैंक यू मिस्टर देसवाल, यू आर वेरी वेल अटेंटिव हियर, और आपको आपका बहुत धन्यवाद. तो ऐसे ही जो रिस्पॉन्ड करेंगे उन पर ध्यान भी दिया जाएगा. ध्यान कर लें लोग, जो रिस्पॉन्ड करेंगे उन पर ध्यान दिया जाएगा, नहीं तो वी विल नॉट टेक एनी लीनियंट व्यू फॉर अदर्स. चर्चा में नहीं रहेंगे, साइलेंट मोड पे रहेंगे, उनका हम बिल्कुल ध्यान नहीं देंगे. ध्यान कर लीजिए. I will make up my mind that they are sleeping. और किसी का कुछ होगा तो हम उसमें कोई लीनियंट व्यू नहीं लेंगे, गड़बड़ है तो गड़बड़ है, काट के जीरो पकड़ाएंगे। आप सभी सुन पा रहे हैं?
यस सर, सुन रहे हैं
यस
सर।
सर।
यस सर।
यस सर, सुन रहे हैं सर।
सर हियरिंग सर।
अब देखिए सर सब बोल रहे हैं। आप लोग ऐसा काम मत करें, ठीक है, जिससे कि जिससे को भाजन का शिकार हो जाए। अरे भाई थोड़ा बहुत बोला करिए, कुछ तो बोल दिया करिए। इसको पढ़िए जरा सा, विपुल मालविया, वेयर आर यू?
यस सर, पढ़ता हूँ सर।
हाँ विपुल जी पढ़िए इसको।
Offences are not cognizable with power of arrest, section 5, 6 and 7. Notwithstanding anything contained in the CRPC 1973, an offence under this act shall not be cognizable. Second, any superior officer or member of the force may, without an order from a magistrate and without a warrant, arrest any person who has been concerned in an offence punishable under this act, or against whom a reasonable suspicion exists of having been so concerned. Every person arrested for an offence under this act shall.
Okay.
Third point, every person arrested for an offence under this act shall, if the arrest was made by a person other than an officer of the force, be forwarded without delay to the nearest officer of the force.
Thank you very much विपुल, आपका भी ध्यान रखा
Welcome,
है।
sir. Welcome,
Very
sir.
Very good. So power of inquiry has been given under section 8 and 9. ज्यादा इसमें कुछ देखने की जरूरत नहीं है। सर्च ऑफ वारंट एंड एग्जीक्यूशन अंडर सेक्शन 10 and 11. Power of courts to order for future vehicle under chapter 13, under section 13. Overriding power of act under section 14. This has been given and इसको आपसे बहुत ज्यादा ताल्लुक नहीं है। I come to compare with this and please and note down पनिशमेंट का क्राइटेरिया देख लीजिएगा कि कितना पनिशमेंट है। सो पोजीशन बिफोर अमेंडमेंट, पेनल्टी, दिस वाज द हेडिंग, पेनल्टी फॉर unlawful possession of railway property. Now position after amendment in 2012, the amendment has been done. Penalty for theft, dishonest misappropriation or unlawful possession of railway property. Whoever commits theft or dishonestly misappropriates or is found or is proved to have been in possession of any railway property suspected of having been stolen or unlawfully obtained shall, unless he proves that the railway property came into his possession, lawfully be punishable. यहाँ से who will read this? This A, who will read?
Sir, I will read, sir.
Okay.
For the first offense with imprisonment for a term which may extend to 5 years, or with fine, or with both, and in absence of special and adequate reasons to be mentioned in the judgment of the court, such imprisonment shall not be less than 1 year, and such fine shall not be less than 1,000 rupees.
Okay. Second, for the second and subsequent offense, पढ़िए।
For the second or a subsequent offense with imprisonment for a term which may extend to 5 years, and also with fine, and in the absence of special and adequate reasons to be mentioned in the judgment of the court, such imprisonment shall not be less than 2 years, and such fine shall not be less than 2,000 rupees. Explanation:
हाँ पढ़िए पढ़िए.
For the purposes of this section, theft and dishonest misappropriation shall have the same meanings as assigned to them respectively in section 378 and section 403 of the Indian Penal Code.
Okay. This section 378 defines the offense of theft, and section 403 defines the criminal misappropriation. And here I would like to request everybody, so please keep in mind the criteria of punishment which is oftenly asked. For the first offense under RPUP Act, who commits first offense, maximum punishment is 5 years, minimum is 1 year and 1,000 fine, and for the second and subsequent offense, 2 years minimum and 2,000 rupees fine is the maximum. So please keep in mind these punishments. So position before amendment section 4 and position after amendment section 4. Anybody can read section 4 please. Position after.
Punishment
Yes.
for
सर आई कैन रीड लेकिन
connivance
स्लाइड
at
नहीं दिख रही
offense.
मेरे को तो.
Yes
Sir, I will
please.
read.
हाँ आमिर पढ़िए आप.
Punishment for connivance. Punishment for connivance at offences. Any owner or occupier or occupier in charge of the management of that land or building who willfully connives at an offence against the provisions of this act shall be punishable with imprisonment for a term which may extend to 5 years or with fine or with both. Explanation. For the purposes of this section, the words abet and conspire shall have the same meanings as assigned to them respectively in section 107 and 120A of Indian Penal Code.
Thank you, Mr. Amir Khan. Inquiry how to be made. Who will read this? Pankaj, आप पढ़िए जरा. पंकज कुमार.
मुझे स्लाइड ही नहीं दिख रही सर मुझे.
स्लाइड नहीं दिख रही है.
यस सर, बस सुनाई दे रहा है, दिख नहीं रहा सर, कैसे पढ़ूंगा.
तो बाकी कैसे पढ़ ले रहे हैं आप? किससे जुड़े? मोबाइल से जुड़े?
यस सर, मोबाइल से जुड़ा हूँ लेकिन कुछ इंटरनेट इश्यू है सर, इसलिए नहीं दिख रहा.
अच्छा चलिए, आपने रिस्पॉन्ड किया उसके लिए धन्यवाद. आपका भी ध्यान रखा जाएगा. एनीबॉडी कैन रीड? एनी फर्दर कैन? देखिए आपके सियास का तो हमेशा ध्यान रखा जाएगा. चिराग झा का, सुचिता अरोड़ा का, बाकी जो लोग रिस्पॉन्ड कर रहे हैं, जो लोग रिस्पॉन्ड नहीं कर रहे हैं उनको मैं ऐसा समझ रहा हूं कि हो सकता है कि नींद में हो गए हो ऑन करके. जाग जाइए, चैन से सोना है तो जाग जाइए. चैन से सोना है तो जाग जाइए. हेलो हरीश.
यस सर.
पढ़िए. पोजीशन आफ्टर
अमेंडमेंट.
जी.
Inquiry how to be made. When an officer of the force receives information about commission of an offence punishable under this act, or when any person is arrested by an officer of the force for an offence punishable under this act, or is forwarded to him under section 7, he shall proceed to inquire into the charge against such person.
ओके, थैंक यू वेरी मच. तो इसका सैलियंट फीचर, रियल प्रॉपर्टी की डेफिनेशन और जो अमेंड हुए हैं सेक्शन 3, 4, 8, ये सब ध्यान से पढ़े रहिए और इन पर फोकस करिए. और मैं यहाँ पर इसको खत्म करूंगा. थैंक यू वेरी मच एंड प्लीज I will share you this presentation